Well, hi again. It's Rob Ryder, and it is Monday, March 17th, 2025. And today, TILA, would be the Truth in Lending Act, in state law is protected by the Constitution. A lot of stuff being said there. That this federal act, which is the Truth in Lending Act, has been incorporated into the state's laws. And so, if it's in a state law, and then the state denies you equal protection under the law, well, that's a 14th Amendment violation of the Constitution. And you should be able to file a complaint with, like, the FBI. Right? So, but before we got there, maybe we can get the state to do the right thing and say, well, it's in the state law. So, the part of the state law it's in has to do with your state's Consumer Financial Protection Act, or whatever your state calls it, which is probably enforced by the state attorney general or the local prosecutor, and the local prosecutor. But how do you get it to them? Right? Well, they have a way sometimes to do it online, but you could go down and file a complaint with the police department and get the police report. So the idea being that if the state isn't going to give you relief, then you have the proof that you went to the state first, and now the state is denying you equal protection of the law, and that would make it a 14th Amendment violation. And you could file a complaint with the FBI, because that would be a crime against the United States. You know, you may be the victim, but the crime is against the United States. It's against the Constitution. So we're going to see if that works. So let's, with all that said, let me show you where it comes from. Give me just a second here. So just as an example, I took Texas, put Texas Truth in Lending Act. Just put the name of your state, Truth in Lending Act behind it, search, and you'll start finding things that have to do with Texas, that come up. And right, well, and you can see right there in the administrative code, it talks about the Truth in Lending Act, 15 U.S.C., da 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 da. And under this finance code, page, Truth in Lending. Well, sure enough, right? Part C, Truth in Lending Act, and Truth in Lending Act, 15 U.S.C. 1601, the whole thing. So it's in consumer credit protection. Now, it may not be this particular chapter that you're looking for your answer, but it doesn't mean it's not in there. So like in Michigan, I can go to this page here, Michigan Legislature, and I can search on the Michigan compiled laws by keywords. Well, put it in quotes, Truth in Lending, hit search. And, there's various sections that have Truth in Lending in, even though they don't show up in the description. They're buried in there somewhere. So, it's been incorporated into the state law. Here are a couple other examples. So let's say Tennessee, for example, right? That it is a violation of this chapter for any person subject to this chapter to fail to comply with any other state law or federal law or rules, regulations promulgated under the state or federal law applicable to any business authorized to conduct under this chapter, including but not limited to the Real Estate Settlement Procedures Act and the Truth in Lending Act. Well, there it is. Well, what's the violation? The disclosure's wrong. That's the violation. It's deceptive practices, where they're supposed to give you this disclosure that has the APR, annual percentage rate, and the finance charge on it. And as it turns out, well, you can calculate the finance charge if you know what the APR is with a few other bits of information that come off the disclosure. So you can check their math to see how they did and agree that their APR is correct and disagree with the disclosed finance charge, which is always disclosed understated by much more than $100. And because of that, well, it's a violation of the Consumer Protection Act, or the Truth in Lending Act. right? Ohio, a licensee may engage business in making loans provided that each loan meets all the conditions here. So what are they? Well, one of them was any disclosure required under the Truth in Lending Act. Okay, well, it has to be right according to the Truth in Lending Act. Truth in Lending Act is the one that says if it's disclosed by more than $100, understated by more than $100, that it's outside of the tolerances of the Act. So, and then there was this blurb that the CFPB, which is the Consumer Financial Protection Bureau, which really doesn't exist, determines Truth in Lending Act does not preempt New York, California, Utah, Virginia commercial financing disclosure laws. So whatever all that means, right? They're trying to, it may not preempt it, but it doesn't mean that it doesn't apply. I just haven't gone to look in those states to see where it is. But let's just talk about the CFPB real quick, which is the Consumer Financial Protection Bureau, which gets a lot of news now because DOGE is trying to shut it down. And people are all up in arms. Well, we're going to be harming consumers by closing it down. Well, let me show you something. Here's a perfect example of what's going on, right? In the background, you see CFPB right here, but what's on the door? Bureau of Consumer Financial Protection, not CFPB. Because, in fact, Frank Dodek created the Bureau of Consumer Financial Protection. It did not create the Consumer Financial Protection Bureau. And so this is just a perfect case of where the agency has been overrun by some administrative coup that created something completely different, and now it's the one that's controlling it. So getting rid of the CFPB has to be done. That would be the law because it doesn't really exist. And all this stuff to do with the Truth in Lending Act falls under, at least for the part that we're interested in now with the disclosure, right, falls under Title 15 the United States Code, Chapter 41, which has to do with consumer credit protection. And if we go down here to definitions, it says the Bureau is the Bureau of Consumer Financial Protection. Bureau of Consumer Financial Protection. Huh. Seems to me there's been some usurpation going on. Okay, well, that's what that says. Let's go a little further into it real quick. And just, let's see if I can remember where all this stuff is. Disclosure guidelines. Here we go. Determining finance charge. So it tells you all the little bits and pieces that make up the finance charge and what the tolerances are. Does not vary from the actual finance charge by more than $100. Well, if it does, then it's wrong. That's all you have to say. It doesn't. You don't have to even know what the exact number is. You just need to say that the disclosed finance charge is understated by more than $100. And they're going to say, well, what did you use to figure that out? Or to preempt them from saying that, you just show them how you figured it out. So the easiest way I think to do it, this removes all the, takes you out of the picture. Now we're talking about artificial intelligence, right? So use Grok or whoever you want to use. And, I've talked about this in previous videos, but then I was talking about, have it calculate the APR and the finance charge. But in reality, just let them have the APR to be correct, whatever they put. That's what you say it is, that's good. So if you already know what the APR is, right, how do you calculate the finance charge? And that's what this was about. You could ask Grok, say, Grok, I know what the APR is in percentage rate, and I know how much I was borrowed, right? And I know what the term is, right? That's what this is, T. Anyways, this is going to tell you that the formula to figure out the finance charge is the P, which is the principal, or the amount of the loan, the amount financed, the APR, which is the annual percentage rate, but you're going to have to make it into a decimal instead of being as a percentage. And then the T is the term in years, right? And say, okay, we'll do the math. So that's what it did. If we had these three values right here, it says the finance charge would be 2,250. Well, you could tell, okay, well, use my values and put your values in there. So as an example, right, on mortgages that are newer than, like, I think 2015, have a closing disclosure that looks like this. But before that, and still currently with like car loans and so forth, you have a disclosure that looks something like this. And so to figure out finance charge based on Grok's formula, finance charge equals the APR times the amount financed times the term in years. So finance charge equals, right, 23.56%, which is 0.2356 as a decimal, times the amount financed. Where's that? It's right there, amount financed. Yeah, 23,715.70. Bring it on down. And term in years. Well, it's a 72-month loan. Divide 72 by 12, and you get 6. Multiply those together, and it's 33,524.51. Well, what did they show? What did they disclose as a finance charge? 20,814. Well, we can definitely say then that the disclosed finance charge is understated by more than $100. If we're going to use their APR and a formula provided by artificial intelligence, the disclosed finance charge is understated. Well, that'd be now that's a violation of state law because the disclosure's wrong. It's a deceptive act and practice under Consumer Financial Protection. Now the state has to protect you. If the state won't protect you, well, then that makes it a 14th Amendment violation, and you could file a complaint with the FBI. You would hope we don't have to go through all that. I mean, I'd like somebody just to agree and give us a relief, but that hasn't happened yet. But it doesn't change, the logic string, so that's all I'm looking at now. So what's the logic to this system? And the logic is, well, if this number is more than the disclosed finance charge, then it means that the disclosed finance charge is understated. And according to law, well, if it's understated, then it's wrong. So they violated the law, period. I don't have to clean up behind them. I just need to point out their mess. So how about one like this? Well, on the first page, really all you need is the loan term, which would be normally in years anyway, so that's 20 years. And the rest of the information is on the 5th page, where you get the calculated finance charge or the disclosed finance charge, the amount financed, and the annual percentage rate. Okay, well, Grok says finance charge equals the APR as a decimal, 0.06103, times the amount financed, 116,400, times 20, for the term in years equals 142,077,884. And yet all that's been disclosed is 85,438.92. Definitely understated by more than $100. Right? That's all there is to it. Don't make it any harder than that. Before we go on to the FBI and what all that could mean, I just wanted to show, this came out of the video I did, my last video, where why is this so slow? Right, TILA Tales, a judge, esquire, and an owner walked into it was a foreclosure hearing in which the defendant had brought up the fact he had asked for a hearing because he had discovered that the truth in lending, that the disclosed APR was understated. And up until then, he had put in 5 or 6 other motions. Nobody paid any attention to it. He put that in, and the very next day, the plaintiff put in a motion asking for a hearing. So they really weren't working on his asking for a hearing. They were doing it on the plaintiff's asking for a hearing. which is always the case. They don't pay any attention to you because, you know, the whole thing is a scam that they're doing. Judge don't have proper oath of office, go on for all the things that are wrong. But nevertheless, they had the hearing, and the guy brought it up, and the judge or the plaintiff brought up their stuff, and the judge said, well, I want to take a break for a second. And then he asked both parties, hey, can we have a status conference? And they agreed. So the judge came down from his perch. His little court follower wheeled up a chair behind him, and he sat down. And as he was sitting, he was asking the defendant, well, do you want to stay in your house? He said, yeah, of course we do. And they start talking about, well, you know, the court, we see all sorts of things to do with people losing their homes and, you know, foreclosure and so forth. And the guy said, yeah, but how many of those brought up the fact that there's violations of federal law? And the guy said, we ain't going to talk about that. We're here to keep you in your house. Well, the reason for that is in that particular instance, the guy wearing the black robe wasn't a judge. He was a master. In South Carolina, they have courts of common pleas. And so one of their things is the court sends pre-trial stuff to a master. So they're really not talking to the judge in a judicial setting. This is still an administrative hearing of some kind. That's why it's a status conference. So he can't do anything as a judge there because he's not there as a judge. So, you know, so him saying that would be, could be appropriate because it's really the wrong forum. It doesn't mean it's not the right complaint, just not necessarily the right forum. He wants them to work it out. So that's how it was left. They left the courtroom, supposed to work it out. A couple days later, they get some paperwork from the lender saying to, you know, like renegotiate the contract, which is not what they want to do. But we hadn't brought up the fact at that point that this stuff is in state law, which makes the state has to give you equal protection under the law, or equal protection of the law. And the law says, you know, if the disclosure is wrong, well, that's deceptive practice. So give us some relief. That's what we're trying to do, right? We don't want to recalculate the frickin' loan. We want to get rid of it and get the property back, which would include the note, which is really a check. It would include all the payments that you made that are really going to escrow because there was never a loan made. And it would include having the mortgage, which has been recorded and put in the public record that you gave them your house as collateral, would be removed from the record. That's what we want to happen. Why? Well, because it was a deceptive practice. You don't want to do the loan anymore. They never lent you any money for the house. It never happened. So with all that in mind, what had happened just before the hearing was that this supplemental affidavit got filed by the plaintiffs for the attorney, which is supposed to be from the foreclosure service manager of Carlington Mortgage Services, who goes through this thing, and he's going to say that a true and accurate copy of the note is attached here to and incorporated herein as Exhibit A, and plaintiff's counsel shall have the original note in his possession at any time in hearing regarding foreclosure. So the defendants told me, he said, well, he was there in the courtroom, obviously, and that the plaintiff's attorney had a copy of the note. But it wasn't the same copy that is in the exhibit. And so here's the exhibit. All right, this is the exhibit they put in, and so the note looks like this, where it's got shit blanked out on it. And then it comes down here, and it's been stamped without recourse, pay the order of. Right, it's been endorsed. And if you read the very first line of what it is, it says, in return for a loan I have received, I promise to pay to the order of the lender. Well, that made this a check. Anytime you pay to the order, it's a check. Okay, well, they took your check, the NTFN Incorporated took your check, and they deposited it. And then sometime later they said, well, we have it now, NTF, right? And they're going to give it, the collateral department has your check as collateral, but they're going to go ahead and pay it over to Homeward Residential Incorporated. And then Homeward was going to give it to MB, but apparently that got voided. But it didn't stop them from later doing it in a lodge, right? Where Homeward Residential now is going to pay to the owner of Oaken Loan Servicing, LLC. Okay, well, that's the last one that's in here. So nowhere in here does this show that this has been transferred to the current plaintiff, which is Carrington Mortgage Services, right? They're not on the note. So how come they got the note? The note should be with Oaken Loan Servicing, LLC. The point is, it's a check, right? And they should give you this back. And this isn't what they had. All they had was, basically the note, as the note was given by you to them without any of these allowances on the bottom or any of these endorsements. What does that mean? Well, it means that the attorney for the plaintiff is not the counsel for the plaintiff, because this thing said that the counsel for the plaintiff. Right, that true and accurate copy of the note is attached here too and incorporated in it as Exhibit A, and that and the plaintiff's counsel shall have the original note in his possession at any hearing regarding the foreclosure. So either it's the master or it's the clerk. One of those two have got the note. They're the plaintiff's counsel, because it isn't the attorney for the plaintiff. And then when I have also determined the plaintiff provided the original note to the plaintiff's counsel, and the plaintiff's counsel did, in fact, receive the original note and is in custodial possession of the original note. The plaintiff's counsel, not the attorney for the plaintiff, the plaintiff's counsel. A counsel is a different office than an attorney. I mean, I could be your attorney. Just sign a power of attorney. I'm your attorney. I can sign for you. That kind of stuff. I can't give you legal advice. That's what the plaintiff's counsel does. Okay, so obviously the first thing is you try to do it with the state, right? Because it's in the state law, and you want to point that out and say, hey, they violated the state law. And you're looking for equal protection of the law. And if they don't give it to you, well, then you're going to have to file a complaint with the Federal Bureau of Investigation, for the reasons I'm going to show now, right? That according to the 28 USC Chapter 33 on the Federal Bureau of Investigation, Federal Bureau of Investigation is in the Department of Justice. That's good to know. Now this part gets me, because it says here that the director of the Federal Bureau of Investigation, that the Attorney General may appoint the director of the Federal Bureau of Investigation. Why ain't that something? Then why did President Trump have to go through all that shit to get Kash Patel confirmed to get the Senate to bless off on it? Well, I did find something in something else, and I don't want to get, that's a whole different issue, right? But anyways, we saw what it said. So we do have somebody who's been appointed as the director. But then it goes on to say the Attorney General may appoint officials to detect and prosecute crimes against the United States. Well, that's what happens when you violate the 14th Amendment. That's a crime against the United States. It's not a crime against you. You're just the victim of a crime against the United States. So they can investigate. Okay, well then, what do you need to do to let them know? So the quickest way is probably go to the electronic tip form and fill it out. Or you could go down to your local FBI office and talk to them. Whatever you got to do, right? But there is a way to do it. And so what would you be complaining about? Well, without too much problem, you can search the internet and find this components of federal criminal law It's from the Congressional Research Service, but if you just put in components of federal criminal law, sure, it'll show up. You'll be looking at the same thing. And if you want to put in Congressional Research Service report R48177, you can find it that way too. But in here, it talks about things that make a federal criminal law. And what does that mean? These are crimes against the United States, right? Like anything in Title 18 is a crime against the United States. You may have committed it, or you may be the victim of it, but the crime is against the United States. And that's the shit that the FBI can enforce. And, this tells you where all the things come from to make it. And it mentions that, hey, we got some Reconstruction era amendments, being the 13th, 14th, and 15th Amendment, that get captured in this. Let's take a look at those real quick. All right, Reconstruction era amendments, where each amendment announces certain rights, such as that the government may not deprive individuals of equal protection of the law. Well, there you go. That's what we're trying to get. Let's go look at that. That's the 14th Amendment. I don't want to get into the 13th Amendment. I want to talk about the 14th. So, in relevant part, the 14th Amendment provides that no state shall make or enforce any law which shall abridge the privileges, immunities of citizens of the United States, nor, now it's got a semicolon, so that's done. We're done talking about citizens of the United States. Let's continue on. Nor shall any state deprive any person, didn't say citizen of the United States, it said any person. Indian non-tax, well, that's a person. Right? Any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So now, who's in the jurisdiction of the United States? Right? Everybody that's, well, in this case, this had to do with state law. So, well, who's in the jurisdiction of the state? Well, they have you in foreclosure court. Apparently, they think that you're in their jurisdiction. So, there you are. All right, so let's continue on. Section 5 of the 14th Amendment grants Congress the power to enforce by appropriate legislation the provisions of this article. There are two important limits to Congress's Section 5 power. The first, the Supreme Court has indicated the 14th Amendment by its very terms prohibits only state action. So you can't bring up a federal crime under the 14th Amendment. You can only bring up a state crime. Accordingly, the Congress' power to enact legislation under Section 5 is limited to legislation addressed at remedying state action. A state action may come in a number of forms, perhaps most relevant to a criminal law context. The state action requirement may be satisfied where an individual acts under color of law. Well, that would be a judge, somebody who's claiming to be a state judge. We're under Title IV of the United States Code, Section 101. It talks about that every member of the state legislature and every executive and judicial officer of the state, judge, master, clerk, attorney and counselor at law, I should say. You got to have the proper term, not just an attorney, because I could be an attorney. But there's the office is called attorney and counselor at law. Any of those are state officers. They all need to have taken this oath. I, A.B., do solemnly swear I will support the Constitution of the United States. Where A.B. then is their name. So you can't use a middle initial. That's not your identity. They have to do this right. And then it has to be administered and recorded according to 102. And, well, this shit isn't happening. So the fact that the guy's there saying he's a state judge is already color of law. Now, it doesn't mean he can't give you the relief you want, right? Because while he may not really have jurisdiction over you, he has jurisdiction over the attorneys or the plaintiff. All right, may be satisfied where an individual acts under color of law. Ka-ching. Somebody pretending to be a judge who didn't take the oath in 4 U.S.C. 101. Generally, an individual's actions under color of law are under color of law if their conduct involves misuse of power, possessed by virtue of state law, and made possible only because the wrongdoer is clothed in the authority of state law. Typically, individuals acting under color of law will be government employees or officials. There are also some instances which conduct private individuals or entities may be attributed to the state itself, although determining whether that is the case is a necessary fact-bound inquiry. So you got to ask the question. Supreme Court has said that there must be a close nexus between the state and the challenged action. So that seemingly private behavior may fairly be treated as the state itself. So while this master doesn't have an oath to be satisfied 4 U.S.C. 101, he's still acting like he has judicial authority. So that's the behavior, private behavior, acting like a judge. My point is, for that reason, you can file a complaint with the FBI. Which means you go here and hit electronic tip form. It's one way to do it. And then, then you have to, start answering some questions, which, this will tell you it's a crime to, you're not required to provide your name and other personal information. However, your failure to supply requested information may impede or preclude an investigation on your tip by law enforcement agencies. By voluntarily providing information on this page, you are consenting to the FBI's use and maintenance of the information. Any information you provide on this website will be used for investigative purposes and may be shared as required by law or other routine uses as permitted with the Privacy Act of 1974. And all applicable routine uses as may be published from time to time in the Federal Register, including routine use of the FBI Central Record System, FBI Data Warehouse, and so forth and so on. And so as it turns out, the FBI is the one that's supposed to be keeping our information on our personally identifiable information. That would be one of these central record systems I'm talking about. Okay, I understand. Let me do that. Cannot be used to report emergencies. Okay, I agree. Not an emergency, don't use it. But you can do these things here, right? This form is used to report federal crimes, submit tips regarding terrorist activity, to reporting internet-based crimes, do something else. Be specific when providing information, so forth and so on, and submit your information only once. Okay. Other crimes, send it to these people. I didn't want to do that. Okay, warning. You're entering the U.S. government website. Indicate agreement. I understand that repeatedly providing tips with no investigative value will result in my tip not being considered. And the information I provide on this form is correct to the best of my knowledge. I understand that knowingly and willfully providing false information could make me subject to a fine, imprisonment, or both. It would make you violating, committing a crime against the United States, basically. Title 18, United States Code, Section 101. You hit those and you agree, and pretty soon you come to here. Now you got to make a choice. Well, which of these do you think it is? Civil rights, corruption, so forth and so on. Well, they have this one here for other FBI crimes, so that's the one I would hit. Other FBI, because I'd say, well, it's a violation of the Constitution. That's what I want to tell them. Cannot be used to report emergencies, so forth and so on. Okay, well, you already told me that. That's good. Subject information. Do you have information about who committed the crime? Well, yes, of course. That's why you're here. Continue, and then you fill in some information. Or if it's a business, well, then you click this, and it'll change that, and you'll put in different information. Right? But unfortunately, I can't go any further on this. But I've done one. I don't have a loan to do a thing. What if I did a different one? So let me grab that. We'll take a look at it. So anyways, mine has nothing to do with the consumer financial protection laws. Mine had to do with something to do with the Department of Defense. Where I'd asked the Department of Defense for some information on the Privacy Act, and I got this reply back. It said it would give me 15 pages of stuff, and it didn't give me 15 pages, and whatever it gave me was frickin' blank, right? Crossed out, blank. It's like, well, what kind of shit is this? Then I looked, said, well, this is Robert A. Rytlewski, which is not the name I gave them when I asked for the stuff, right? As far as the military is concerned, I'm Rytlewski, Robert Allen. That's what's on my DD4 form 4. Right? One of the very first pieces of paper you fill out when you go to enlist in the military is the DD Form 4 enlistment reenlistment document, Armed Forces of the United States. Right? They have your name, Rytlewski, comma, Robert Allen. And they don't put a comma between Robert and Allen. So Robert Allen is my first name. Then a social security number or your DOD ID number. Right? So this is how they get you in to start with. And if you go down here far enough, now that you're going to do this contract, and you get to this section here under section 9, it says that we understand that we may still be in the military. And if you are, as long as you're in, my enlistment reenlistment agreement is more than an employment agreement. It affects a change of status from civilian to military member of the armed forces. And as a member of the armed forces of the United States, I will be entitled to receive pay, allowances, and other benefits as provided by law and regulation. Well, brother and sister, if you ever enlisted, you've never been released. Title 10, United States Code, Section 506, talks about extending your enlistment during a time of war until the president terminates your enlistment. And if you ain't got a termination letter, then you ain't out. And you don't have a termination letter. And President Trump got Congress to agree, or the people pretending to be Congress, to agree in his first term, where they agreed together and they acknowledged the fact that we have been at war continuously since December 7th, 1941. One long war. If you enlisted since 1941, December 7th, you're still in. I'm not disagreeing with it. Pay me. That's what I want. If nothing else, what it would mean is, okay, I served 8 years on active duty, and I'm still in. So I'm still continuing my time, although I'm not getting any more pay or promotions. But come the age 60, I am entitled to have a retirement. I can't get it for 20 years of active duty service. That's a special provision under statutory law. But it also says that at age 60, if you're in the military, you can claim your retirement. So that's what I'm fighting for. Right? And just to show you, well, how do they make you confirm your enlistment? This is where you take your oath. Right? This is the oath of enlistment. According to regulations in Uniform Code of Military Justice, that's what I'm leaning on now, because I took the oath. And so according to regulations, Uniform Code of Military Justice, I'm still in the military. But when you fill this out, not only do you fill it out, but an officer, enlistment reenlistment officer, certifies it also. So you have a bilateral business contract with the Armed Forces of the United States, and it's being suppressed. Well, knowing all those things, now let's go back to the FBI. So here we go, right? This first page, yeah, got to do that. And that's going to warn you. Got to check some boxes and agree. I did that. Pick one of these, and I picked other. But unfortunately, when I picked other, I didn't say it was like equal protection of the law, which I could have. Or maybe I did. We'll find out. Let's see what I did. Warning, warning. This website cannot be used to report emergencies. Yeah, I get it. Not what I'm doing. Subject information. Yeah. Who is it? Well, it's the person that signed this damn letter. That's who this is against. Now, there may be others, but I'll let them figure that out. But this document where they've, stole my identity, basically, because they're not calling me Rytlewski, Robert Allen. And I certainly don't have a middle initial. I could almost agree. Well, you can call me Robert Allen Rytlewski. Yeah, I'd use that too. But I'm never going to be Robert A. Rytlewski, ever again. And that they gave me 15 pages, and that didn't happen. And so who did it? Well, this person here. Sorrel Sletsnik. All right, Sorrel, then guess what? You're now the part of an investigation, if you can believe what they're saying. So I just took all the information off of the thing, right? It's all on there. Where he was, what the address is. Then you get this, other FBI crimes questions. So, what crime are you reporting? This is where, if you were doing this as a consumer protection, you would say violation of your 14th Amendment rights. That's what I would do. Your right to equal protection of the law. I said crimes against the United States, Privacy Act of 1974. Theft of armed forces of the United States, veterans, service members, personally identifiable information. When did it happen? Well, the date that's on the letter I got. Other FBI crimes, where did the crime incident occur? Well, Virginia, Alexandria, the DOD OIG office. How do you know this information? Well, because I got a case number. And then what did I complain about? I said that a Department of Defense Office of Inspector General employee concealed my official identifying full name, Rutluski, Robert Allen, and replaced it with a pseudonym, Robert A. Rutluski, as part of a scheme to ensure an armed force United States enlistee is denied access to his records protected under the Privacy Act of 1974. My DD Form 4 enlistment document contract established Rutluski Robert Allen in as the name issued DOD ID number 12112800006. According to the Privacy Act of 1974, my name is National Security Confidential, personally identifiable information. Yet the accused substituted a false identity, Robert A. Rutluski, in case number DOD OIG 2005-000712, denying my access to records of Rutluski, Robert Allen. My contract, DD Form 4, with the United States is signed by both parties and evidence as the United States intended. I receive pay allowances and other benefits, but actions of the accused prove a conspiracy to wrongfully withhold my contractual entitlements. And you only get 1,000 characters, and guess what? That was exactly 1,000 characters. I couldn't even have put another jot or tittle. I used them all up, so I figured it must be good. And then I said it's for myself. Now, here's another thing. I should have probably said it's for somebody else and said it's a crime against the United States. I wish I had done that, because I don't know what happens if you put this here instead. Because you can always go back. I said it was for myself. I should have said, no, it's a crime against the United States. I'm just the victim. And then well, who is it? I put my information in. So I imagine if you had said it to somebody else, it would have been something like this. And you would have had to have an address. And so what's the address of the United States? Hard to say exactly, but you get the point. So anyways, put it in. Did I report it to law enforcement? Well, yes, I did. I had actually reported this to the Arlington Police Department first. And I got a case number, right? Put it all in. They were happy to take it, so submission successful. So they have it now. And that was yesterday, right? So I haven't heard anything yet. I don't know if I'll hear anything. I'm just saying I could, so I did. And that's all I'm suggesting that you do if you can, right? That because there's a new sheriff in town, we got to test the system and see if we're going to get any relief. And the only way to do that is to file the frickin' complaint. And again, the reason for it is well under 28 U.S.C. 533 that the Attorney General may appoint officials to detect and prosecute crimes against the United States. And what are crimes against the United States? Well, one of them is, color of law, 14th Amendment violation. I know it's 18 U.S.C. 242, I think 241, 242, same thing, but I'm going to say no, it's a violation of the Constitution. It ain't statutory. This is common law. It goes all the way back to the amendment. Which that's another thing I'd like to say about this contract that we have, which would be simply this. If you're an enlistee and you filled this out and both parties signed, well, you don't have a statutory claim with the United States. You have a common law claim. you got two parties signed a contract and it's not being contract's not being fulfilled by one of the parties. So that's common law. Which is why, when you saw the choices you had at the FBI and it had other, right? Well, that's what I'm saying. That's for common law. That it's not necessarily a statutory crime. It's a common law crime. So I'm going to leave it there. That's where we're at now. Hopefully that somebody that has a TILA problem will file a complaint with the local police department to say that the TILA is, it's covered by state law, by the state's Consumer Financial Protection Act, or whatever the hell it is, and that the disclosed finance charge, calculated using a formula provided by artificial intelligence, shows that the disclosed finance charge is understated by more than $100, and therefore it's in violation of the law. Period. You're going to report a crime. You're the victim, right? In this case, the state is the one that the crime is against because they violated a state law that incorporated the Truth in Lending Act into the state law. Right? So this all comes under your state's Consumer Financial Protection Act. If you find anything they're talking about disclosures, that's what we're talking about, is just the disclosures that go with the Truth in Lending Act have been made part of state law. And so if you're denied equal protection of the law now that it's in the state law, well, that's a violation of the 14th Amendment right to equal protection of the law. Okay, very good. I'm going to leave it there, and you all have a great day, and we'll see what happens next. See you now.